Medico-legal concerns can prompt changes to the practice of medicine that can be both potentially beneficial and not beneficial to patient care. Each year, Australians spend approximately $1 billion per capita rate on cosmetic surgery. This is 40% more than Americans. Cosmetic surgery is a lucrative industry that a growing number of Australians are willing to pay thousands for to make significant changes to their appearance. Every year, Australians are consuming over $250 million worth of Botox procedures, having 8,000 breast augmentation surgeries and 30,000 liposuction procedures. Medical malpractice is where a healthcare professional or provider neglects to provide appropriate treatment, omits to take an appropriate action, or gives substandard treatment that causes harm, injury, or death to a patient. The malpractice normally involves a medical error. This could be in diagnosis, medication dosage, health management, treatment, or aftercare. Trusted Surgeons is a non-for-profit that helps facilitate patients on choosing a qualified surgeon for their elected plastic and cosmetic surgery. Today we will be talking about the state of liability of medical negligence in Queensland, the current system, and also reforms that are necessary for progression and patient safety. The Medical Board of Australia does not recognise cosmetic surgery as a specialty practice of surgery. The board does recognise plastic surgery as a specialty practice. The medical specialty of plastic surgery includes both cosmetic surgery and reconstructive surgery. Reconstructive surgery differs from cosmetic surgery as, while it incorporates aesthetic techniques, it restores form and function as well as normality of appearance. But who can perform this specialised area of medicine? In order to hold a title of specialist plastic surgeon, a specialist plastic surgeon will have to have an extensive surgical education and training, including a minimum of 12 years medical and surgical education, with at least 5 years of specialist postgraduate training. However, currently in Australia, it is legal for any doctor with a basic medical degree to perform surgery. One of the main objectives of tort law is to protect individuals from negligent torts and compensate those who have been affected. Negligence is the failure to exercise the level of care that a reasonable person would have exercised in similar circumstances. In 2008, the Health Legislation Amendment Bill was submitted to Parliament to protect children, teenagers, and young adults from cosmetic surgery and the high risks that are associated with it. A doctor or other healthcare professional is expected to prove a certain standard of care. A medical practitioner has a single comprehensive duty covering all the ways in which they are called upon to exercise their skill and judgment. The Civil Liability Act 2003 was enacted in Queensland for cases that involve negligence. The courts must establish whether the doctor owes the patient a duty of care. The courts do this by examining the doctor's conduct and determines whether a reasonable person would have done the same under similar circumstances. Generally, in the law of torts, a defendant will owe the plaintiff a duty of care in two situations. The first being, does the relationship between the plaintiff and the defendant fall within an established category? If this relationship falls into an established category, the courts are required to impose a duty of care. A doctor-patient relationship is an established category of duty. In Rogers and Whittaker, a cosmetic surgeon will only be held liable in circumstances where it can be determined that the cosmetic surgeon owed the patient a duty to take reasonable care to avoid causing the patient damage or loss. The second is whether it is a novel fact situation. Courts adopt the incremental approach, the salient feature approach, or the reasonable foreseeability approach to determine whether the defendant owes a duty of care to the plaintiff. Under a code of conduct for doctors in Australia, the doctor has a duty to care for the patient in line with the right medical practices and rules. Cosmetic surgeons have a legal duty to exercise reasonable care and skill when handling patients. If the cosmetic surgeon makes an error that a reasonable professional in the same field would not have committed, and the patient suffers injury or harm as a direct result of their error, the patient is entitled to compensation. All cosmetic surgery practitioners have a duty of care to ensure a patient's safety and well-being and to avoid unnecessary injury. A breach of duty is the failure to exercise reasonable care. Once a duty of care has been established, the next step is to determine whether the defendant breached that duty of care. The onus to prove a breach of duty rests with the plaintiff, per Section 12 of the Civil Liability Act. Under Section 12, the injured patient bears the onus of proving on the balance of probabilities any fact that is relevant to causation for the liability for breach of duty. Section 9, subsection 1 in the Civil Liability Act states that a person does not breach a duty to take precautions against the risk of harm unless the risk was foreseeable, the risk was not insignificant, and in the circumstances that a reasonable person in the position of the person in question would have taken precautions. Section 9, subsection 2 states that in deciding whether a reasonable person would have taken precautions against the risk of harm, the court is to consider the following: the probability that the harm would occur if the care were not taken, the likely seriousness of the harm, the burden of taking precautions to avoid the risk of harm, the social utility of the of the activity that creates the risk of harm. There is a code of conduct for doctors in Australia that states, cosmetic surgery practitioners have a duty to obtain the patient's consent for any procedure. The cosmetic surgeon must disclose all the information on the benefits, consequences, and potential risks involved, in addition to providing other alternatives to the procedures. An individual gives informed consent after learning and understanding the potential risks and benefit involved. Failure to obtain informed consent before undertaking any procedure is a breach of duty. Cosmetic surgery practitioners have a duty to exercise a high degree of competency and care when handling patients. If a plastic surgeon fails to exercise the level of skill and care that a reasonable plastic surgeon should provide under similar circumstances, and the patient suffers harm as a result of this, the surgeon is held to be liable. Once the courts establish that a duty of care existed and that the duty of care was breached, the patient must then prove that the breach was the actual and immediate cause of the harm suffered. A necessary condition test has replaced the but-for test. This test allows the Australian courts to adopt a common-sense approach to causation in cases where the but-for test did not produce a fair and just result. Since departing from the Bolam test, the courts now apply the reasonable patient test as opposed to the opinion of a reasonable body of doctors. Majority decision in Rogers and Whittaker held that the law should not recognise that a doctor had a duty to warn a patient of a material risk inherent in the proposed treatment. A risk is material if, in the circumstances of the particular case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach a significance to it. In medical negligence cases, the claimant bears the burden of proof on all the elements to their case. Section 11, subsection 1A and B of the Civil Liability Act tightens the principles of causation. It requires proof of more than factual causation to establish liability. The legislation requires the defendant should be held responsible in those circumstances. Section 11, subsection 3B, any statement made by the patient after suffering the harm about what he or she would have done is inadmissible except to the extent, if any, that the statement is against his or her interest. Establishing causation on the basis of failure to warn a patient before a procedure has proven to be a difficult task in medical negligence cases. Establishing whether or not a claimant would not have undergone the procedure had he or she received sufficient advice or warning is an obstacle the claimant has to overcome. A surgeon who has breached the duty to warn of inherent material risk is only liable if the patient suffered harm due to the breach. In Wallace and Cam, the High Court requires proof of more than factual causation to establish liability. The court held that the scope of liability was the critical question in the case. Would the defendant's liability extend to the injury sustained in those circumstances? The court found it was not. The Australian courts use a subjective test of causation, whether the actual claimant would have proceeded if sufficiently advised, as opposed to the hypothetical reasonable man would have done. In Rosenberg and Percival, the plaintiff's claim failed, as she failed to prove causation. The patient must prove the practitioner's breach caused him or her to suffer actual and measurable harm. There are many risks associated with plastic and cosmetic surgery, such as infection, anesthesia risks, and suboptimal aesthetic results, to name a few. Some of the most common negligent claims in cosmetic and plastic surgery include asymmetry and pain, which may persist. If a person suffers side effects from failure of cosmetic surgery in Australia, they are protected under legislation if all of the elements can be successfully proven. However, if a person decides to be a medical tourist, a person who travels overseas to have their procedure and has a negligent outcome, they will have to go through a more complicated procedure to receive any sort of compensation. There is no direct regulation or legislation in place for overseas cosmetic surgery. Regulations of accreditation and how procedures are marketed on social media for national and international surgery is a necessity for progressing in patient safety. There is confusion in the community about titles, membership, and qualifications, which adversely impedes informed consent, leading to rushed decisions in some cases. One submission to the Medical Board of Australia's recent consultation on the cosmetic surgery asserted that patients rely on the belief that the industry is properly regulated when they make decisions about which service they choose on the basis of price. Furthermore, advertising regulations for the medical workforce makes it difficult to advertise on the basis of suggesting to the clients that one medical practice has better professional standards than another. Cosmetic and plastic surgery procedures are actively marketed and promoted extensively and aggressively in most areas of the media. The advertising of these procedures focuses on the benefit for the consumer, downplaying or not always mentioning the risks. There is a common concern about public demands for these procedures driving an inappropriate business activity to meet this demand. The cosmetic, medical, and surgical industry is highly mobile, with indirect and direct advertisements that transcend state borders. Before and after photos are a common part of advertising cosmetic and plastic procedures. Since the social media generation, practitioners have taken on semi-entrepreneurial roles in advertising and selling their services via social media, and even using social media influencers to offer inducements such as discounts or gifts.
To get, discounted rates, do collaborations with different cosmetic surgeons and stuff like that.
Kate gets free treatments in return for endorsements on social media.
A big laser clinic, actually. I was their ambassador for about a year. I had some cosmetic fillers, had all my laser and everything like that free, facial treatments free for like a whole year. I was meant to have the BBL done by a certain surgeon in Sydney, but I backed out of it. But yeah, he contacted me to have it done like half price, but yeah.
So he contacted you out of the blue?
Yes.
And asked you to get this BBL done?
Yes. And I went and saw him for a consultation, and at the time I was kind of keen because I had my best friend getting it done. And so I was like, yeah, why not? I'll look into it. But then as soon as, he booked in the date and everything to have it done, I was like, I'm not getting it done anymore. I sort of, got scared and backed out.
These advertising techniques have received concern by social researchers and others over the years about the wider health and social impacts of promoting these types of procedures. With the rapid ad hoc growth has opened the way for unregulated practices and questionable methods of promoting, posing ethical dilemmas for some members of the medical profession, consumers, and legislators. The internet has opened up promotional opportunities for overseas cosmetic surgeons to easily advertise their business within Australia. An Australian Broadcasting Corporation program indicated that there were more than 15,000 Australians travelling abroad just for cosmetic surgery. This is estimated to be a $300 million a year industry for cosmetic tourism by Australians. Cosmetic surgery tourism raises particular safety issues for the patients. These package tours leave the patient not knowing their surgeon or their qualifications or anything about where the procedure will take place. Patients would need to navigate medical complaints and legal systems abroad if they wish to take action against a healthcare provider or facility in the event of malpractice and/or serious complications of medical treatment. At present, there is no agreed medical compliance or legal frameworks internationally to cover medical tourism. Overseas medical treatment is unlikely to be covered by Medicare Australia or private healthcare insurance. Australia does not have a comprehensive national no-fault compensation scheme. Queensland does not have a no-fault compensation scheme for medical injuries. Instead, we have a fault-based compensation scheme. The onus is left on the plaintiff to prove to the court that the doctor had been negligent. If the patient is unable to prove all of the elements of negligence, they will not be able to be compensated for the loss they have suffered. This is a weakness in our current system. There are other disadvantages of a fault-based system. Claims are settled slowly, the reporting rate of negligence will be reduced, and an increase in unnecessary fees used in the judicial and administrative process. There are a few advantages of a fault-based compensation scheme. They include reducing the number of claims, flexibility to deal with different cases, easier to avoid entitlement issues, and it can adapt to societal changes. The Australian government needs to strengthen its guidelines on who can operate on patients. Patients have no way of knowing whether their surgeon is properly qualified and has undergone specific training in cosmetic surgery. Cosmetic surgery needs to be recognised as a medical specialty, which would establish national standards which any university or medical college training program could apply to have its standards accredited. Establishing an accreditation will provide clarity for consumers so they can make informed choices. A system of accreditation to provide better and safe outcomes for patients needs to be established nationwide. In 2018, the Queensland Government established legislative changes to surgical cosmetic procedures regulations under the Private Health Facilities Act 1999. This meant the Queensland Government has restricted the location where doctors may perform major cosmetic surgery, such as abnoplasty and breast augmentations. This legislative change is aligned with the Victorian Government's Health Legislation Amendment Quality and Safety Bill 2017, which aims to close a loophole that has allowed cosmetic surgery to take place in unregistered facilities. Other jurisdictions should align with the Queensland Government and Victorian Government's legislative changes. The Australian Health Practitioner Regulation Agency needs to be enforcing their medical advertising rules and creating guidelines for the use of social media and advertising cosmetic procedures and the use of social media inside the operating theatre. The Australian and Queensland Government needs to regulate the excessive marketing of overseas cosmetic surgery in Queensland as well as nationwide. The public's perception of cosmetic and plastic surgery is that it's quick, easy, painless, and with little or no risk. This perception is far away from the truth, where most procedures are extremely complex and require a high degree of surgical skill and aesthetic appreciation. Reforming medical negligence in the field of cosmetic surgery is an important topic the government, both state and federal, as well as the colleges and the Medical Board of Australia, needs to regulate in order to prevent unsafe procedures, and unnecessary deaths from rogue medical practitioners calling themselves cosmetic surgeons. Another issue that needs further regulations attached is the advertising of cosmetic procedures, especially on social media. These unregulated practices and questionable methods of promotion are posing ethical dilemmas for some members of the medical profession, consumers, and legislators.
Unless the governments around Australia come together to ensure that there are proper regulations in place, we will have more people die, we'll have more people harmed, and it will become an industry that becomes impossible to regulate.